United States of America, and to the republic
for which it stands,
one nation,
one nation,
under God,
under God,
indivisible,
indivisible,
liberty and justice for all.
justice for all.
All right, roll call, please, Amy.
Mr. Cadigan?
Present.
Ms. Donahue?
Present.
Mr. Hain?
Here.
Mr. McGuffich? Do we have member McGuffich?
Yes, he's on the call.
We lose him? Okay, I just can't see. Okay. Ms. O'Brien?
She just should be joining, Amy.
Okay.
Okay, great.
Let's see. Ms. Watson?
Present.
All right,
Thank you.
Kate's here.
I'm here.
Great. And
Watson,
Member
present.
Watson's here.
Okay. Vice Chairman Linneberry?
Member Linneberry, or Vice Chairman Linneberry is not present, and I have his proxy.
Correct. Thank you. Chairman Schultz?
Present. All right, we will turn this over to Ms. Malowitz, our General Counsel, for this lack of apparent conformity of petitions. Barney?
Yes, thank you, Chairman. The following petitions for nomination have failed to meet minimum standards of apparent conformity to be placed on the November 3rd, 2020 general election ballot. Filed as a slate, the following candidates submitted 216 signatures for the following offices: Don Blankenship for President of the United States, William Allen Moore for Vice President of the United States, and Chad N. Copy for United States Senator. The signature requirements for these offices under the Libertarian Preliminary Injunction Order is 2,500 signatures, and thus the apparent conformity threshold is 250 signatures. Slated candidates have submitted 34 signatures fewer than necessary to meet the apparent conformity standard. Each candidate was mailed a letter on July 22nd advising them of their petition's lack of apparent conformity. For the aforementioned reasons, I recommend removing candidates Blankenship, Moore, and Copy from the November 3rd general election ballot.
All right, are there questions for the General Counsel on that, or is there a motion to strike these from the ballot?
And so moved.
All right, motion by Member Hain, second.
Second.
Second, Member Watson. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Schultz?
Yes, those names will be stricken.
Also filed as a slate, several candidates submitted 77 signatures for the following offices: Kyle Kenley Kopitke for President of the United States and Taha Ivan Iwanow for Vice President of the United States. The signature requirement here is also 2,500 signatures with an apparent conformity threshold of 250 signatures. The candidates submitted 173 signatures fewer than necessary to meet the apparent conformity standard. Each candidate was mailed a letter on July 22nd advising them of their petition's lack of apparent conformity. For these reasons, I recommend removing candidates Kopitke and Iwanow from the November 3rd general election ballot.
All right, any questions or discussion? If not, is there a motion to remove those two names from the ballot?
Move that we accept the recommendation of the General Counsel for removal.
Second.
Motion made and seconded. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Schultz?
Yes. All right, is there a motion to recess the State Board of Elections and reconvene as the State Officers Electoral Board?
So moved.
Move. Second.
All right, roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Schultz?
Yes. All right, so we'll now sit as the State Officers Electoral Board, and we're going to have the General Counsel call the cases, and we've accepted the appearances for everyone listening in. You know, in the typical course of business, we would all be either in Chicago or Springfield, and you would be assigned your hearing officers and dispatched to various conference rooms and so forth to get started. Obviously, we can't do that now. This is all going to have to be done through Zoom. So I'm going to have Marnie explain how this is going to work today in these unusual circumstances. Ms. Malowitz, can you explain this for everybody?
Great, and as Chair Schultz mentioned in the past, initial status conferences on objections to nominating petitions were held immediately following this meeting, but due to COVID, statuses will be held via teleconference or Zoom either today the 3rd or tomorrow the 4th, based on the preference of the assigned hearing officer. So if you are present on this call, if you're an attorney representing a candidate or objector and you have not filed an appearance form, please do so immediately, either now or before the conclusion of this meeting. If you are a candidate or objector who is proceeding without an attorney, we still need an appearance form from you with your email address on it so that the hearing officer can contact you about the initial status conference and when it will be scheduled. The board's appearance form can be located on elections.il.gov under the Candidate Filings and Results tab on the right side of the screen. State Officers Electoral Board, and there's a drop-down menu of documents, and you'll see that appearance is one of these documents that can be downloaded. Please email the appearance to generalcounsel@elections.il.gov. And candidates and objectors, if you have trouble downloading an appearance form, you can email a request for an appearance form, again, to generalcounsel@elections.il.gov. Candidates and objectors, please ensure that you're on the lookout for an email from your hearing officer who will provide information for the initial status conference. And once your appearance is filed, all questions should be directed to your hearing officer, not to the board or to the general counsel. Records examinations are tentatively scheduled to be held in Chicago on August 6th, 7th, and 10th. Your hearing officer will notify you of the date and time of any records examination that is necessary in your case, and the schedule will also be posted to the board's website. Of note is that each party will only be entitled to one watcher present at the records examinations due to COVID, and we will discuss this more when the board considers the rules of procedure. Finally, we're going to be calling the cases in a few minutes, and I genuinely apologize to anyone whose name I mispronounce. I have my name mispronounced all the time, but so I know how it feels, but unfortunately that doesn't help me to know how to better pronounce your name. So again, I apologize, I'm doing my best.
Thank you, Ms. Malowitz, and I hope I pronounced it correctly. You want to go ahead and then call the cases?
Certainly. The first case, Smith versus West, 20 SOEB GE 101. We do not have an appearance on file for Objector Smith or for candidate West. So if anyone is available for either of those cases, if you could please speak up.
All right, is there anybody on this call that is here to represent the parties on Smith versus West?
And I know Amy Kelly may need a moment to locate those individuals. Amy, if you can give us a thumbs up if we're okay to move on, if no one is here.
I don't have any messages or information that anyone for that case is in the waiting room or waiting to speak.
Okay, thank you, Amy. Mr. Chairman, would you rather recall this case later in the list?
Yeah, let's just move on. Thank you, Marty.
Okay, the next case, 20 SOEB GE 102, Smith versus Kuna Jacob. We also have no appearances on file for that case. Is there anyone present for either case?
Anyone on this call that is either Smith or Kuna Jacob?
No.
All right, let's move on that one too then. Go ahead, Marty.
Next case, 20 SOEB GE 103, Stogdell versus Keating. We have appearances on file here by objector Adam Stogdell, as well as an appearance on behalf of the candidate by Vito A. Mastrangelo.
All right, are both of those parties represented on this call?
I see Mr. Mastrangelo. Is Mr.
Present.
Stogdell on the call?
Present.
Thank you.
Great. Thank you very much. All right, moving on to the next case. 20 SOEB GE 104 Vieira versus Thronberg. We have an appearance on behalf of the objector by John Fogarty and an appearance on behalf of the candidate by Scott Erdman. Is Mr. Fogarty on the call? And how about Mr. Erdman?
I am here.
Okay. Again,
Mr. Fogarty's not on the call yet, because I think he's going to be heard on the proposed supplemental rule.
okay.
Or no, on Ruggieri, I believe. Anyway, John Fogarty not on the call at this time? All right, we'll move on, Marty.
Okay. Another thing of note, though, in the Vieira versus Thronberg case, the hearing officer who will likely be assigned, Mr. Goen, would like to hold the status conference immediately following this meeting. So please keep an eye out for an email from him because he wants to have that meeting as soon as possible. The next case, 20 SOEB GE 105, Dart and Wagner versus McManaman. We have an appearance for the objector by Cherie Langenstein and an appearance on behalf of the candidate by candidate McManaman. Is Ms. Langenstein on the call? And how about candidate McManaman?
I'm present.
Great. Again,
Good job with my name.
thank you. And again, Ms. Langenstein, is she on the call? Okay, not yet. We'll move on. 20 SOEB GE 106, Hall versus Schluter. We have an appearance on behalf of the objector by John Fogarty, and we do not yet have an appearance on behalf of the candidate Schluter. Mr. Fogarty, have you joined?
I have, and I apologize. I had some issue with signing in, so I bet I missed a couple of my cases perhaps already. There was an issue, I think, with the Zoom login. Did anyone else experience that or no?
I don't know, Mr. Fogarty, but what was it? Vieira versus Thronberg, I believe you're on that case.
Yeah, I filed an appearance in that one as well. So.
And you're going to be heard later on Ruggieri?
I will as well if you'll hear me.
Okay. All right. Go ahead, Ms. Malowitz.
And Mr. Fogarty, on case 104, Vieira versus Thronberg, hearing officer Goen would like to have the status conference immediately following this call.
Sure.
If people could place their computers on mute, as well as any phone lines on mute to try to eliminate some of the background noise, that would be very, very helpful. Thank you. I think that's helping. But yes, so for case 104, please keep an eye out for an email from Mr. Goen so that he can immediately schedule the status conference.
Great, thank you.
Back to case 106, Hall versus Schluter. Mr. Fogarty, you're here on behalf of the objector. Is anyone
That's
here is anyone here on behalf of candidate Schluter? Candidate Schluter? No? Okay. Moving on to 20 SOEB
Hello.
GE 107, Hall versus Graff. John Fogarty has appeared on behalf of the objector. And
Hello.
Whoever's saying hello, can you please mute yourself?
Oh, I just wanted to ask a question real quick. I'm sorry. Is this the hearing for the objectors or the candidates?
This is where the case is assigned to a hearing officer, and you'll find out how to proceed today. What case are you here on?
I'm the candidate, Paris Walker Thomas, and my attorney is here.
Pardon me, if I may, I have some clarification. Ms. Walker Thomas, I believe that your matter is being heard with the Chicago Board of Elections.
Okay, I just wanted to make sure.
State Officers Electoral Board.
Okay, and can you give me that information? I'm sorry.
Because
We're here, and they didn't let me, hold on one second.
I'm so sorry to interrupt. However, we are at the place where we were contacted to be, and nobody can tell us where her hearing date is, what the court number, what the number is, whether the city has it or the county has it. So we really apologize for interrupting, but
Well,
we
that's
don't want
okay.
her to miss.
But you're not on the agenda for this meeting, I don't believe.
I don't
that
think
correct?
we are either, because
Yeah.
her case was passed to a different jurisdiction, but we can't get any information on where it is, and we don't want to miss it. So the only
Okay.
information she has is this board of election. So I don't know.
Okay, well, we're in the middle of a meeting right now.
Yeah.
But if you want to contact us at the close of the meeting, I'm sure somebody at the State Board of Elections can put you in touch with Chicago Board of Elections. Otherwise, I think that's who you need to contact.
Okay.
Thank you. All right. Can you
Thank
go ahead, Ms. Malowitz?
Certainly. We were on case 107, Hall versus Graff. John Fogarty has appeared on behalf of the objector, and Ellen Graff, the candidate, will be appearing pro se. Candidate Graff, are you here on the phone?
Present.
Great, thank you. Next, 20 SOEB GE 108, Archie versus Haas. A appearance has been filed by John Fogarty on behalf of the objector, and I do not yet have an appearance on behalf of candidate Haas. Is candidate Haas on the line, or someone on his behalf or her behalf? Candidate Haas? Seeing none, I will move on to the next case. 20 SOEB GE 109, Hardin versus Kuna Jacob. I do not have an appearance on file for either party. Is objector Hardin on the line?
Yes, Council Malowitz, John Fogarty for the objector.
Okay, sorry, sir, I somehow
Oh,
didn't.
that's okay. Oh, no, no, I sent that maybe 25 minutes ago or so.
Okay, sounds good. I'm running a few minutes behind on my
No.
schedule. And how about objector Kuna Jacob? Oh, excuse me, candidate Kuna Jacob. Is anyone on the line for candidate Kuna Jacob? All right, seeing none, we'll move on. The next case, 20 SOEB GE 110, Collier versus Elmore. I see a appearance by Kevin Morphew on behalf of objector Collier, and an appearance by candidate Elmore on behalf of himself. Is Kevin Morphew on the line?
Yes, Kevin Morphew is here.
Good morning.
Morning.
And candidate Elmore, are you on the line? Okay, seeing none. Moving on to 20 SOEB GE 111, Pettit Senior versus Keating. I have an appearance on behalf of objector by Kevin Morphew, and an appearance on behalf of the objector by Vito Mastrangelo. Mr. Morphew, I know you're on the line. Mr. Mastrangelo?
Yes, I am on the line.
And how do I pronounce your name? I apologize.
Very close, Mastrangelo.
Close, Mastrangelo. We'll see if we get it right next time. Thank you. The next case, 20 SOEB GE 112, Collier versus Music. We have an appearance on behalf of the objector by Kevin Morphew, and we do not yet have an appearance on behalf of candidate Music. Is anyone here on the line on behalf of candidate Music? Candidate Music? Okay, seeing none, moving on.
Excuse me, Ms. Malowitz?
Yes.
Yes, my name is William Redpath, and I just got into the meeting. I am a candidate who's been objected to, but I was not able to get into the meeting using the link that was in the public notice from last Thursday. That didn't work. And also I tried calling in to the area code 312 phone number, and that didn't work. And maybe that's why a lot of people aren't on this call. I only found out the correct Zoom address by calling the State Board of Elections and was told that the link for the Zoom meeting went to a meeting that was scheduled for 2 weeks ago today, July 20, and that didn't work. So I had no way to get into this meeting until I called at about 10:40 a.m. the State Board of Elections and gave me the correct Zoom address, and that's the only reason I was able to get into this meeting.
Okay. Thank you for letting me know about that. James Eccles, if you are on the line, or Joanna Sharp, if you could take our email list and email out to everyone the correct dial-in information as soon as possible, that would be very, very helpful. And that way, at least the information is getting out to anyone who has provided their email address. Thank you for bringing that to our attention, Mr. Redpath, and your case has not yet been called.
Hey, Marnie, I would like to interject for a moment. When you called for Mark Elmore, he is on this call. It's just he didn't unmute himself. I did look on the list, and he is on the list.
Oh, okay, perfect. And I already have his appearance, so I will scratch him off my list. Thank you. The next case up is 20 SOEB GE 113, Riley versus Grimm. I have an appearance on file from Mr. Morphew on behalf of the objector. I do not have an appearance on behalf of candidate Grimm. Is candidate Grimm on the line, or anyone on behalf of candidate Grimm?
Yes. This is candidate Grimm. I am on the line.
Hi, candidate Grimm. If you could fill out an appearance form off of our website and email it in to generalcounsel@elections.il.gov.
I have just emailed that in. I'm gonna say, not to waste anybody's time, but everything that William Redpath just said was the same scenario here, where we had no idea that this was being moved to Zoom. We were on our way to Springfield, so we're taking care of this all right now.
Certainly, and we'll do our best to reach out to as many people as we can to ensure we have the correct information. I'm not quite sure how that happened.
Mm-hmm.
Yeah, and while we're on that, Marnie, Steve Stanvoss, you're in Springfield?
No, Mr. Chairman, I'm in Chicago.
Oh, you are? Okay, I just wondered if anyone showed up in Springfield. You know, couldn't get in and didn't get the information on the call like these other parties. We don't have anybody in the office right now, do we?
Yeah, Mr. Chairman, apparently there was a mistake on the public notice. It was the incorrect link to the meeting. However, the correct information was sent to all the people who filed appearances. But unfortunately, not everybody filed an appearance ahead of time.
All right. Okay, well, hopefully, before we get to these records exams and you know, after the hearing officers are assigned, the parties can get proper notification.
Chair Schultz, I can.
Yes,
I can run.
Davis.
Yeah, I can run to the office. I'm 5 minutes from the office. Would it be helpful if I ran over there real quick to make sure there's nobody?
If you don't mind doing that, Brent, I was disturbed to hear that people were in their car heading to Springfield because they hadn't got the notice that we decided to go to Zoom because of the COVID in the office. I understand we did have deep cleaning Friday, so wear your mask, but be careful. But thank you for going over there.
Sure.
And excuse me, this is Bill Redpath once again. I did file an appearance via email on Friday, and I do not recall getting a notice changing the Zoom address. I did not see such a notice.
Yeah, that was prior to Friday, I think.
And again, I've asked my staff to send out correct information to anybody whose email addresses they have. We will send someone to the Springfield office. I know there's at least one person in the Chicago office in case anyone shows up in person. It's unfortunate this mistake happened, and I apologize, but we'll do our best to get everyone we can on the line.
Okay.
All right. May I
Go
proceed
ahead,
with calling
Marty.
the cases?
Yes.
20 SOEB GE 114, Williams versus Bielert. I have an appearance on behalf of Objector Williams by Mr. Morphew, and I have an appearance on behalf of candidate Bielert by Pericles Abbasi. Mr. Abbasi, are you on the line?
I'm here, yes.
Great, thank you. Next case is 20 SOEB GE 115, Turner versus Wilson, excuse me. We have an appearance on file for the objector by James Morphew and an appearance on behalf of candidate Wilson by Andrew Finko. Is Andrew Finko on the line?
Yes, I'm him here.
Great, thank you. The next case, 20 SOEB GE 116, Braun versus Copy. I do not have appearances on file for either party. Is anyone on the line for Objector Braun? Objector Braun? And is anyone on the line for candidate Copy or Copy? Candidate Copy? Okay, moving on to the next case, 20 SOEB GE 501. That's Morris, Tenor, Bradley, Spagnolo, and Johnson versus West. I have an appearance on file for the objectors by Ed Mullen and Luke Casson. Mr. Mullen or Casson, are you on the line?
This is Ed Mullen. I'm not sure who the other person that did the appearance was. I don't believe that person represents my clients.
Okay, perhaps that was a mistake. Thank you for pointing that out.
Okay. Marnie, Ms. Malowitz, I did get two numbers on the case that I've filed an appearance on. That may be the confusion. There's 501 and 507. I'm not sure which is my case yet. So.
Okay.
That's not it though.
Okay. You're representing Mr. Landon?
I am not.
No. Okay. Well, when I get to the other case, you'll let me know if that would be okay. And I'm sorry for the confusion. And, you know, it's difficult when we're calling this many cases. We're trying to get our logistics together, and it was easier back in the day when we could all be in one room and figure this out. But under the COVID situation, we're doing our best with Zoom and with teleconferences, and I apologize if it takes a little more time than it would have to do this in person. So is anyone on the line on behalf of candidate West? Candidate West? I note that for case 501, hearing officer Tenuto would like to handle the status hearing immediately following this meeting if possible. So please be on the lookout for an email from Mr. Tenuto.
Thank you.
The next case is 20 SOEB GE 502, Adams and Jones versus Pellegrini. We have a appearance on file for the objectors by Valeria Adams and Devin Jones. Are Ms. Adams or Mr. Jones on the line?
Valerie Adams is on the line.
Good morning.
And Devin Jones as well.
Hello. And we have an appearance on file by Ruth Pellegrini. Is candidate Pellegrini on the line? No. Okay, moving along.
Marnie, I think so. I think some people are having trouble unmuting.
Oh, this is Amy Kelly running the call, and you can see that she's there. Pellegrini. Candidate Pellegrini.
Hi, she's trying to get on right now. My name's Gus Gonzalez. I'm her campaign manager.
Okay.
Okay, great. All right, well, I will scratch that one out. And actually calling the next case is also Miss Pellegrini. 20 SOEB GE 503, Adams and Jones versus Pellegrini. Again, we have appearances on behalf of Valeria Adams and Devin Jones, and appearances on behalf of candidate Pellegrini. So you're all here. Thank you. The next case, 20 SOEB GE 504, Bixler and Perkins versus Redpath. I have an appearance on behalf of the objector by Jeffrey Meyer.
I'm present, thank you.
Thank
yes,
you.
I'm present today.
And I have an appearance on file for the candidate, William Redpath. I know, Mr. Redpath, you're on the line.
Yes.
Please note that for case 504, Hearing Officer Gowan will most likely be assigned, and he would like to hold the status conference immediately following this meeting. So please be on the lookout for an email from him so that that status can happen immediately. The next case, 20 SOEB GE 505, Flores versus Cleveland. I have an appearance on behalf of the objector by Kevin Morphew. I do not have an appearance filed on behalf of candidate Cleveland. Is anyone here on behalf of
I am present.
Hello, candidate Cleveland. Thank you for being here. If you could send an appearance into general counsel at at elections.il.gov. Again, that's general counsel.
Okay, I just sent an appearance form a couple minutes ago, so.
Okay, perfect.
Thank you.
The next case, 20 GE 506, Kies versus Sarfraz. I have an appearance on behalf of the objector by Kevin Morphew, and I have an appearance on behalf of candidate Sarfraz by Mr. Mastrangelo. Did I get it right that time?
Thank you. Yes.
Thank you. SOEB GE 507, Landon versus Copy. I have an appearance by the objector, Mr. Landon. Mr. Landon, are you on the line? Luther Landon. Okay, and is anyone on the line?
Marnie, he was on the line. I'm not sure if he got dropped, but I do remember signing him in.
Okay, thank you. And is anyone on the line on behalf of candidate Copy or Copy?
Ms. Malowitz, this is Luke Casson. I have got a receipt for the objection number 507 on Gonzalez versus Brown, which I filed an appearance on behalf of Mr. Gonzalez. Has the number been changed?
It may be, sir, that is an objection that is heard by a different election board.
I am Taya Yvonne Iwano with Dr. Kyle Kenley Kopicki.
Okay, and whoever was just speaking, I'm sorry, who was that was Mr. Casson? Casson, if you can call into the board after this meeting, we will try to figure out where your objection is and where it's being heard.
Thank you.
No problem.
Madam Malowitz, I am representing Kopicki Iwano. I am Taya Yvonne Iwano.
That case has already been called and disposed of. Chairman, how would you like to handle that?
This was under lack of apparent conformity petitions?
Correct.
Yeah, and who are you, ma'am?
My name is Taya Yvonne Iwano. I was actually robbed and beaten when I was collecting signatures for ballot access, and I just got out of the hospital.
Terrible.
Yeah.
Sorry, so do you represent Chad in Copy, K-O-P-P-I-E, for U.S. Senate?
His name is Kyle Kenley Kopicki for president, and Taya Yvonne Iwano for vice president.
Okay, gotcha. That's just, yeah.
That's who I thought he was calling, Kopicki, not Kopke.
Okay, no, we had two different names back to back there. They were both KOPs, but your petition was stricken for lack of apparent conformity.
Correct. I did get under the allotted amount due to COVID. Hardly any people wanted to sign ballot access.
Yeah, so the board has already ruled that those two names are to be stricken. They won't appear on the ballot because you did not have enough signatures.
Are we still able to be wrote in?
The write-in is a totally separate procedure that you would talk to your local election authority. Okay?
Okay, thank you.
There's a separate filing for that. Thank you. Go ahead, Ms. Mellis.
Great. Back to case 507, Landon versus Copy. Is there anyone here on behalf of candidate Copy? Okay, seeing none. 20 SOEB GE 508 Boot Jr. versus West. I see an appearance for the objector by Pericles Abassi, who is here. Is there anyone on the line for candidate West? Anyone for candidate West? Seeing none, I've made it through the initial call of cases. Chairman, do you want me to recall cases in which someone wasn't present?
Well, yeah, let's do that briefly. Going back to the beginning here, there was no one here on Smith versus West. Is there anybody on that case? Candidate or objector? Smith versus Kuna Jacob? Go ahead, Marty. You probably have a better list than I do.
Certainly. Dart and Wagner versus McManaman. Candidate McManaman is on the line. Is there anyone, is Ms. Langenstein here on behalf of Dart and Wagner?
Yes, I am.
Okay, thank you. 20 SOEB GE 106 Hall versus Schluter. We know Mr. Fogarty is on the line on behalf of objector Hall. Is anyone here on behalf of candidate Schluter? Seeing none. 20 SOEB GE 108 Farshi versus Haas. Mr. Fogarty is here on behalf of the objector. Is anyone here on behalf of candidate Haas? 20 SOEB GE 109 Hardin versus Kuna Jacob. Mr. Fogarty is here on behalf of objector Hardin. Is anyone here on behalf of candidate Kuna Jacob? Candidate Kuna Jacob. 20 SOEB GE 112 Collier versus Music. We have an appearance on behalf of objector Collier by Mr. Morphew. Is anyone here on behalf of candidate Music? Candidate Music. OEB GE 116 Braun versus Copy. I do not have any appearances on file for this case. Is objector Braun here? Objector Braun. And how
Marty,
that
is that the same copy that has been stricken for lack of comparative authority?
Yes, and we'll get to that
Okay.
in a bit, but yes, and that could be the reason. So we'll discuss that again in a bit. Good catch. Thank you, Mr. Chairman. Okay, and 20 SOEB GE 507 is also against Mr. Copy. So let's call one more time, 20 SOEB GE 508 versus West. Mr. Abassi has appeared on behalf of objector Boot. Is anyone here on behalf of candidate West?
Mr. Abassi, is that the same West that we struck for lack of, or no, we haven't struck that for lack of
No,
comparative
you haven't struck Kanye
No,
West.
that's not yet. No, that's I'm sorry, that was my mistake. I thought he was in agenda item 1. Go ahead, Ms. Melowitz.
Nope, there are 3 objections against candidate West, but no one has appeared. Well, I've made it now through the list twice, and to the extent anyone is not here, they are marked as not here. Chairman, to the extent that an objector has not appeared, are you wanting to consider dismissing their objections, or because of the login issues, should we not do that at this time?
Yeah, I mean, I'm welcome to hear from my colleagues on the board, but I would think that maybe there's an opportunity for the hearing officer to connect with some of these people who did have an issue with getting on today's Zoom call. So it'd probably be better if we didn't strike them at this time. Does anybody else wish to be heard on that?
Oh, Mr. Chairman, I'm sorry. You're saying that we should strike those cases now, or?
I was thinking we should wait, Member Cadigan, and see if there's, as the assigned hearing officer schedules their first conference, maybe there are people that missed today's call that will appear. So maybe it's premature to strike at this time. What do you
No,
think?
I agree with that.
All right. Yeah,
I do too.
we'll go ahead then, Marty.
Okay, if we'd like to proceed to the rules.
Okay, at this point, we have all been furnished copies of the rules of procedure for the State Officers Electoral Board, and we need to approve those rules. Is there a motion to adopt them?
I make a motion that we approve the rules of procedure for the State Officers Electoral Board as set forth in pages 15 through 35 of the board packet.
Second.
All right, motion made by member Cadigan, seconded by member Watson. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes, Mr. McGuffey has tried to contact me during the meeting that he's having computer issues. So I don't know, Amy, if you could check into that or even call him on his cell phone.
Okay.
I think he's following the meeting, but unable to be heard. Maybe just a conference call would work better than the Zoom for him.
I do see that he's here, but he's muted himself, so I believe he just needs to unmute if he can figure out how to do.
Yeah, I think maybe if you could send him a text on his cell phone or something. But in the meantime, I'll go ahead and vote yes as his proxy on approval of the rules. Go ahead with the rest of the roll call, please, Amy.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
Yes.
Chairman Scholes?
Yes, all right, the rules will be approved. Now we have to authorize the general counsel to appoint the hearing officers, and we've all been furnished with the list and the assignment to various cases.
I move that we authorize general counsel to appoint the hearing officers as required in pages 36 through 37.
Second.
Motion made by member Watson, second by member Cadigan. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
Yes.
Chairman Scholes?
Yes, okay, the hearing examiners will be assigned as authorized for the general counsel. So consideration of objections to new party and independent candidates, Ms. Malwitz?
If I could just note for the record quickly before we move on that Director Brent Davis went to the Springfield office to see if anyone was present and trying to attend the meeting, and there was no one present.
Okay, thank you. Thank you, Brent. All right, go ahead, Marty.
Sure, one moment, please. So there were two objections that were filed with the board that failed to meet the standards for objections as set forth in section 10-8 of the election code, which requires as follows. The objector's petition shall give the objector's name and residence address and shall state fully the nature of the objections to the certificate of nomination or nomination papers or petitions in question, and shall state the interest of the objection and shall state what relief is requested of the electoral board. So first, case 20 SOEB-GE 101, Smith versus West. This objection fails to include the objector's residence address and fails to fully state the nature of the objections to the nomination papers, the interest in the objection, and the relief requested. So I would recommend that the board strike case 20 SOEB-GE 101.
All right.
Make a
Go ahead,
motion
member
to
Cadigan.
strike the objections as set forth in item 6 of the agenda.
Second.
Okay, now are you making the same motion, member Cadigan, for Stockdale versus Keating?
That's correct. Cases 101, case 101 and 103.
Okay, I had an appearance by an Adam Stockdale.
This is Adam Stockdale, present.
Yes, do you wish to be heard on this, Mr. Stockdale?
I would like to be heard. Yes, sir.
This would be your opportunity to go ahead. You understand that the motion is to strike your objection.
Yes, sir.
All right.
Okay, I have read over the 10-8, and I do have my objection here. When I did go into the State Board of Election in Springfield, Illinois, the only thing that was told to me by the person there was that there was no PDF file or any kind of form to be downloaded that had a normal filling out procedure. It was just told to me that I needed to have my name being the objector and my information, the objectee of the candidate and their information, and the objections that I wish to object to the nomination. I'm not sure exactly what had not been on this 10-8 as what is being challenged to have it been thrown out. Can I get that clarified?
Yeah, sure. Ms. Malowitz?
There is no relief requested in the objection, so it doesn't say what is to be done with the objection. It also doesn't fully state the nature of the objection. From what I recall, there's an allegation of fraud, but without any specific details.
Like I said, I was not, and with the employee, did not really do the formal type. I mean, I did do the objection on the first. I did say fill the objection to. Like I said, I was not told about the relief. With the hearing itself, I do have actual statute evidence that goes with my objections. So if it can please the board, that if I can be heard, that I can fully back up these objections, if that is okay with the board.
I will note that section 10-8 does require a statement of the relief requested. So if the board can take that into account.
Oh, apologies. I mean, I'm going by the assumption to fill the objection. I mean, it may have been vague in terms, but like I said, I was ill-informed from the state board in Springfield because like I said, there was no PDF file actually on the website or thing. It was just told to me that I just need objector name, my name. So like I said, I'm here and present, and I do have the following statutes that can back up my objections. So I would like to be heard, and I understand that the relief is not there, but given the circumstances.
All right, well.
One other note, he also doesn't list the exact signatures that are being challenged, which is also another
It was not explained. It was not explained to me in full context. Like I said, given the circumstances with pandemic and everything, I mean, things may have been lost, but I have gone through and read and gone through. I mean, I do have a proper case here to be heard, and I would asking the board that I be heard on these, and I apologize that the with the nature of it being. But I mean, I am ready to present this to the board if they would be allowing for the hearing.
All right, well, thank you, Mr. Stockdale. Member Cadigan, you made a motion as to 6A and B. Why don't we, is it all right if we vote on those separately?
Sure.
I think the Smith versus West, case 101, there is no objection there, and you moved that.
No, I'm happy to separate out my motion
Okay.
that we initially strike the objection in case 101.
Let's dispose of that. Is there a
I
second?
had a second on that.
Yeah, Member Watson seconded that. So let's go ahead and vote on Smith versus West. Roll call, please, Amy.
Excuse me, Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Lineberry?
Yes.
Chairman Schultz?
Yes. All right. Then as to case 103, Stockdale versus Keating, or the
Mr.
question
Chair.
for,
Oh, sorry.
yes.
Mr. Chair,
No,
if I
go
could
ahead.
interject one more time, I
Yes.
just wanted to
Go
point
ahead,
out
ma'am.
that Mr. Gonzalez seems to have been asking the board for legal advice on how to complete an objection, and we cannot give him legal advice on that objection.
And that was the point I was going to make, Mr. Chairman. I've heard the comments of the objector, and it really is incumbent upon the objector to fulfill those basic requirements, and it sounds like that wasn't done here.
All right, so you're
And
still.
Mr. Chairman, if I could be
Yes.
heard, an objector's
Yes.
petition cannot be amended or supplemented once it's filed.
All right, so Member Cadigan, you renew your motion, and second by Member Watson.
That's correct.
That's correct.
All right, does anybody else wish to be heard? All right, motion made and seconded to strike. Roll call, please.
Excuse me, Mr. Cadigan,
Yes.
Ms. Donahue,
Yes.
Mr. Hain,
Yes.
Mr. McGuffich,
Yes.
Ms. O'Brien,
Yes.
Ms. Watson,
Yes.
Vice Chairman Littleberry,
Yes.
Chairman Schultz.
Yes. All right, I'm sorry, Mr. Stogdale, but your objection has been stricken.
I'm sorry to, just one quickly, is there a way, I know there is an appeal process to this. Can I get a hold through the State Board of Election to appeal this?
Well, you have to go to circuit court, but again, as
The circuit
the
court,
general
okay.
counsel mentioned, we're not in the business of giving legal advice. I'm sorry, I know that
No,
sounds frustrating.
I understand that, but
we really are
it's
prohibited
city
from that.
council, not state. And
Oh,
like I said,
okay.
I came prepared. The State Board of Election in Springfield, the people that were there, they ill-formed me on how to do it. So I feel that I filled it into the proper, what was told me. I mean, I do understand rules are rules. I will follow them, and as well as the candidate, and that is why I would like to go on record. Like I said, the candidate is not following the rules, and I wish to have been heard, but thank you very much for your time.
Well, I appreciate you participating. Thank you.
All right, thank you. Have a good day.
You too. All right.
Dismissal order will be sent on any case that is being dismissed, so that order can be used in seeking an appeal to the court.
Will it be sent to the email address or in mailing address?
Whatever address we have on file.
Okay, I appreciate it. Thank you very much.
All right, thanks, Mr. Stadell. All right, consideration of objections to candidate petitions for resolutions to fill vacancies. And we heard this case on the 20th, but set it over until today, Light versus Ruggieri. And I think Attorney Casson and Attorney Fogarty are both here.
That's right.
That's correct.
All right. Well, Ms. Malwitz, you want to tee this up and then we'll hear from the objector?
Certainly. Just give me a moment or two to
sure.
Shuffle
Take
through
your
my
time, or
papers
if
and get to
anybody
the right
need
one.
a quick break in the meeting here. We all right? Okay.
I'm prepared if you are.
No, yeah, go right ahead then, Ms. Malwitz.
Okay, this is case 20 FOEB GE 100 Light versus Ruggieri. The office is Senate 52nd State Senate. The candidate is a Republican. The objector is Jermaine Light. The attorney for the objector is Luke Casson. Attorney for candidate John Fogarty. The number of signatures that was required was 1,000, and 1,152 signatures were submitted. However, there was a large volume of signatures that could not be validated or that were stricken, leaving 949 valid signatures, which is below the 1,000 signature statutory requirement for the office.
All right, thank you, Ms. Malwitz. Mr. Casson, the objector, you can go first.
Yeah, this was, we've substantially argued this at the last meeting of the board. This was advanced to this date on the assumption that the federal court was going to rule. The federal court has not ruled on the
in the libertarian case.
Yeah. That's still in briefing. We don't have a specific ruling date set as far as I know. I haven't seen one yet. I understand that there will be one set eventually. The briefing, I believe, is all due by the 7th of August. To summarize, the objection was based on the failure to present sufficient numbers of signatures. That fact is not in dispute. The candidate responds with a constitutional argument that it is entitled to the same relief under Libertarian Party versus Pritzker as independent and new party candidates are.
All right, Mr. Fogarty? Yeah, I think you were trying to intervene in the Libertarian case?
Our petition to intervene is still being decided, or it's being undertaken, being considered by Judge Norgal, and we had hoped for a ruling by this point. We don't have that ruling. Mr. Cassen's framing of the case, it is correct. We have in normal times, not enough signatures. In COVID times, considering what was provided to third parties and independents, we do think we should be held to the same standard, and we would then have enough signatures. While we are waiting for the federal court, I would be grateful if, again, this could be kicked until the federal court rules one way or the other. Otherwise, either myself or Mr. Cassen will be flailing away in circuit court. So the issues are framed and before you, but I think on just for the sake of judicial economy, waiting until the federal court rules would be the proper course of action.
All right, thank you, Mr. Fogarty. Thank you, Mr. Casson. Members of the board wish to be heard on this?
I don't believe, I'm sorry, go ahead, Bill.
No, I am inclined to grant Mr. Fogarty's request to hold this over to our August 20th meeting. Again, I believe that in the interests of ballot access, this is a case that's entirely different from the ones we considered at the beginning of this meeting, where the candidates, even with the lower thresholds, came nowhere close. The candidate in this case got very, very close under some very challenging circumstances. I think it would be an entirely absurd result that a candidate to fill a vacancy for an established party would have such a higher threshold than independents and third parties. I think that we should give Mr. Fogarty the time to intervene in the federal court case, to make that case to the court. Or as he said, this is just going to probably end up being litigated through the state courts under the processes that are available there. So,
well, I agree. I don't think we lose anything by setting this over to the 20th or 21st, I believe, is our meeting. Yeah, August 21st. At which point I think we're going to have to set the ballot. So everything will have to be resolved by then. Does anybody else wish to be heard on that?
I would.
Yeah, go ahead, Senator Haney.
And I'm not suggesting that the meeting or this matter doesn't get set on the 20th, but it really is unlikely that the judge is going to finish all of the briefing and come to a ruling by the 20th, based on what we've done before. So, I mean, it would be effectively a status meeting if Judge Norgal has not ruled, I presume. Is that what the board is suggesting?
I didn't get that impression.
No, I think we have to set the ballot here by the 21st, don't we? Mr. Sandoz?
Yes, Mr. Chairman, the 21st is the statutorily designated certification date.
We can't go beyond that. We have to mail ballots internationally. So one way or the other, I mean, if it's not resolved at the federal level, I think there'll be a motion that you lack your 1,000 signature threshold.
And this is the general counsel, if I may comment briefly. Yes. If we do not come to a ruling today, that will be preventing the parties from seeking relief in circuit court because we will not yet have relinquished jurisdiction. So I would recommend coming to a resolution in this case today so that the parties can seek relief if that is what they choose to do.
Mr. Chairman, that's my view. I think we've heard the arguments. He didn't meet the threshold. He went down one road, and now he's stuck with it. If he preferred to make a constitutional argument, he should have done that early on. He has able counsel who could have done it for him. So I would like to move that we accept counsel's views on this and get this thing done today and let the chips fall where they may. I respect Mr. Cadigan's view, but it's close. What's the phrase? It's close, but no cigar. And this isn't horseshoes. I would just soon strike it and let the lawyers hash it out after we follow the law. The law is he didn't make the 1,000 signatures, and we follow the law.
All
And
right.
if I may be heard at this
Yes,
moment
Mr.
on,
Fogarty.
I'm not certain at all that holding over until the 21st would deprive any of the parties.
Mr. Fogarty, you're breaking up on us.
Relief in state court. Are you hearing me better now?
Yeah, it's better.
And can you start at the
Sorry
beginning,
about
Mr. Fogarty, so we can hear
missed
you?
a lot of that, John. So just
I will.
start
It
over.
was brilliant. It was brilliant. Doggone internet. No, I don't see how waiting until your next regularly scheduled meeting, or if there is an interim meeting, is going to deprive either of the parties of ultimately pursuing this in state court if we have to. And I will say, I'll make the representation to this board. If we are not settled somehow in intervening in the suit that already has decided how COVID cases should be treated, my client's going to have to perhaps seek a different federal venue. So I see no ill effects for holding this over, and I see complication. And Mr. Casson and I, expending a lot of time and effort in state court when the federal court could be ruling at any time.
I just
Mr. Casson, go ahead.
Briefly, in general, I agree with Mr. Fogarty, except for one critical principle is the confluence of the production of the ballot and the appellate process will run right over one another, and somebody is going to be prejudiced by this board's delay, one way or another. There's just no way around it.
And if I may respond to that, the only person who would be prejudiced is my client, who is the candidate. And if there is objection, playing that out, if there's an objection pending, that let's say I lose and I appeal up trying to get relief, or if I win and Mr. Casson appeals up trying to get relief, my client is certified with an asterisk saying objection pending, and he's the one who suffers there, no one else. He's willing to take that on, however, in these circumstances.
So, Mr. Fogarty, what you're saying is you don't have a problem with us ruling today?
Oh, I think the better course of action is to hold this over and allow the federal court to make a decision whether they want to let us into this this case that all of these other candidates have benefited from.
But if that hasn't happened by August 21st, then you understand that we would have to make the ruling.
Oh, I understand, Member Watson, absolutely.
Mr. Haynes, what's your position?
Candice, I really believe we should make a decision today. We should listen to our counsel who says we should. I mean, once again, these are judicial inconsistencies, and we're not following the law. The Illinois statute requires 1,000 names, good names. And all these other factors are judge-made problems, and they're being argued academically. There isn't any specific order from a federal judge allowing this party to intervene. Therefore, the only thing before us is whether this candidate met 1,000 names. The answer is no. Everything else, frankly, are very good arguments by counsel. None of them apply to us and the strict meaning of Illinois law. So I prefer we make a decision and let these lawyers handle whatever they have to do as a result of that.
And Attorney Merowitz?
Go ahead, Member Watson.
Mr. Chairman, I'd like to hear from General Counsel once more time.
All right.
Certainly, and I agree wholeheartedly with Mr. Hain. The Delgado case of the Illinois Supreme Court makes very clear that in ruling on objections, the scope of our inquiry is limited to whether the statute is satisfied. We may not look to outside matters, such as constitutional issues or estoppel issues. The board does not have jurisdiction to rule on those. Any objections of those sorts should go to the court. And by preventing the objector from going to court at this point, he's stuck in a limbo of our making. So I believe that what we need to do is vote on the objection as it is. And if the parties would like to go to whichever venue of court they wish to go to, that is for them to decide.
So in other words, the facts are not in dispute that we're less than 1,000 signatures, and that's the only issue.
That is absolutely correct.
All right. Well, Member Hain, is that a motion then?
Yes, sir, it is, Mr. Chairman. I make that motion that this jury be struck from the ballot.
Second.
All right, motion made and seconded. Discussion, Member Cadigan or others on the board that wish to be heard?
No, I with utmost respect for my colleague, Member Hain, and our general counsel, the case law that was cited was done without a pandemic in mind. And I don't think any of us could have anticipated, and certainly the federal case law doesn't anticipate a pandemic. The current scope of the court's order as applied to those independent third parties sets exceedingly low thresholds for independent and third party candidates. And it would be an absurd result for that not to apply to established candidates. I've been consistent on this position since it was first brought up that this litigation was going to move forward, that it ought to apply to established parties, and I'm not going to depart from that today, again, with utmost respect for my colleague, Member Hain, and for the opinion of our general counsel.
No, and I'm sympathetic, Member Cadigan, to think that, the Libertarians' standard's 10%. That would be, 100 votes in this case. So we'd have nearly 10 times the minimum. But I think Member Hain made a very strong and solid argument, bolstered by our general counsel, that that's beyond us, that we have to deal with the 1,000 statutory requirement.
Right, but guiding all of our work and all the work of the courts in this area is the people's right to have ballot access and choice. So again, I just wanted to add that remark. If there's a motion made and seconded, I'm prepared to vote.
All right. Anybody else wish to be heard? Otherwise, roll call, Amy.
Mr. Cadigan?
No.
Ms. Donahue?
No.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
No.
Ms. Watson?
Yes.
Vice Chairman Littleberry,
No.
Chairman Schultz.
Yes. So what is it, 4-4?
Yes.
So the motion does not carry. So do we have another motion on disposing of this?
I'll make a motion that we hold the matter over until either our next regularly scheduled meeting, and the next meeting is called by the chair, to get a status report by the parties to whether or not Mr. Fogarty's candidate has been permitted to intervene.
All right. Is there a second to that motion?
Second.
All right, motion made and seconded to hold this over to the 21st. I don't know that we have any option at this point, do we, Ms. Malowitz, if the motion to strike failed?
The answer would be that the objector, essentially with a 4-4 vote, the candidate would be placed on the ballot, and it would then be for.
Well, then I withdraw my motion.
All right.
And Mr. Stanvos, you'll confirm that?
Yes. My understanding of the past case law on that is that a motion to sustain the objection that fails would result in the candidate remaining on the ballot. It takes 5 votes for the board to take action, and in the absence of that, the status quo would prevail.
I believe that's right. So again, I withdraw my motion. I think the only thing we need to do with a 4-4 vote, Mr. Chairman, is to state a basis for our votes.
Yes, I think that's right. If this goes to circuit court, we need to make a record. I think Member Haynes stated the record eloquently. Is that adequate, Ms. Malowitz, or you want him to restate that? I think you made a good case on the record that we're required by statute, since it's less than 1,000 vote minimum threshold.
Certainly, and if Mr. Hain has more to say, Member Hain, feel free.
Well, I would argue that the Delgado case is controlling. Illinois statute controls. They're both very clear. The COVID matter is something for the courts to decide, and our options here are to follow the law. We are in many ways a ministerial regulatory body. We don't have any option to go beyond what the statute says and to place people on the ballot which do not meet the threshold. That's my honest view. We are, again, we have a great deal of discretion, but not the discretion to ignore clear case law and clear statutory law. Thank you.
Thank you, Member Hain. Member Cadigan?
Yeah, just that ballot access laws are to be interpreted liberally, and that bars against candidacy are to be strictly construed, and the people's right to endorse and nominate the candidate of their choice is to be broadly construed. And that I believe that if the candidate were not permitted to proceed, that would be an absurd result that isn't contemplated under the court's order. That's my basis for the vote that I cast.
Thank you. Well stated by both parties, or both sides. All right. Let's see. Is that it? Do we need to recess the State Officers Electoral Board, Ms. Malowitz?
No. Are we adopting? Should we adopt the reasoning and rationale for each one of our 4 votes with Mr. Haynes' reasoning and rationale, so that the record is clear?
All right. Well, I will state that I agree with Mr. Haynes' reasoning. And I would say that on behalf of Member McGuffey, whose proxy I have. And you can go ahead and speak for yourself, Member Watson.
I would also like to adopt the reasoning and rationale of Member Haynes for the basis of my vote.
And I believe if he were here, Member or Vice Chairman Linneberry would adopt my reasoning and rationale for the vote that I cast on his behalf.
And Member O'Brien and Member Donahue, go ahead.
I would adopt definitely Member Cadigan's comments for the record.
And as would I adopt Member Cadigan's comments for the record as well.
Thank you. That was Member Donahue and Member O'Brien. All right. I think at this point we can recess the State Officers Electoral Board and reconvene as the State Board of Elections. Is there a motion to do that? Yes.
Chair, if I can intervene on one more matter before we recess here. I wanted to note that on matters 20 SOEB GE 116 Braun versus Copy and 20 SOEB GE 507 Landon versus Copy, though the candidate's petition has been dismissed by the board, I will note that there were 2 objections filed to candidate Copy. And because Mr. Copy may now go to court and seek to be reinstated on the ballot, I suggest we stay the objections filed by Braun and Landon until our next meeting, should a court order Mr. Copy back onto the ballot.
All right. Can I do that, Chair? Yes.
Mr. Chairman, just briefly, I just want to make sure that I get some clarification that the board is forwarding this matter to the agenda for the 21st of August.
Well, we talked about that, but no, I think the board voted and it was a tie, so the motion didn't pass. The motion is strike. So right now, Mr. Keating's on the ballot.
And we will be sending out an order shortly, so that way the parties can seek review in court if that's what they choose.
Thank you.
So your next move then would be Circuit Court, Mr. Stockdale. All right.
Started. Thank you.
Or I'm sorry, Mr. Light, or Mr. Cass. All right, we're all set. Does that conclude everything that we need to do for the State Officers Electoral Board, General Counsel?
As long as we are okay with putting off the Braun and Landon objections until the next meeting, sure.
Yeah, do we need board action on that?
It wouldn't hurt.
Okay. Is there a motion to do that?
I move that we accept the recommendation of General Counsel to hold those matters over as heretofore indicated until the next board meeting.
All right. Thank you, Member Watson. Second?
Second.
All right. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hayne?
Yes.
Mr. McGuffey?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Scholes?
Yes. All right. And so, Mr. Cass and Mr. Fogarty, you both understand what we did today here? They may not still be on the call. All right.
I believe so.
So we're going to move. All right. Yeah, it's up to you to, or actually to the objector as to whether or not they want to go to circuit court, but we've disposed of it.
Okay, thank you.
Thank you, Mr. Fogarty. Thank you, Mr. Casson. All right, is there a motion that we resume sitting as the State Board of Elections?
So moved and asked that we adopt
Waive the
previous
attendance
roll
roll
call.
call. All right, all those in favor?
Aye.
Aye.
Oh, so ordered, and we'll sit as the State Board of Elections and adopt our original roll call. And we will take up this proposed supplemental emergency rule again to hear from Ms. Malowitz.
Certainly. Well, there are 2 components that we're considering today. One is whether or not the board wants to withdraw Rule 225.30C. Additionally, Member Watson drafted some additional language that could be used in lieu of the current 225.30C. So that's the one issue we need to deal with. The other is whether the board will be adopting 225.30D. I will note that I circulated that draft subsection to the clerks in Chicago, as well as Cook County, as well as to the Illinois Clerks Association, and I did not receive any objections, comments, or feedback. So it seems that subsection D is meeting people's expectations. So if you'd like to, oh, I'm sorry.
Subsection B is the one that has the process for rejection. D is in David?
D is in David. Subsection D is in David is due process, requiring the election authority to notify a vote by mail applicant if their application is denied.
Okay, and so these are two separate proposals, Barney?
Certainly, so it might be easier to vote first on whether subsection D will be adopted, and then I realize subsection C is probably going to require some debate.
Okay. D is the one that you, yes, go ahead.
Mr. Chairman, I move that we accept the process as delineated for rejection in subsection D of the notice of emergency motions.
And I'm prepared to second that, but are there any members of the clerk community on the call that?
Yeah, we're going to get to them in a minute, Bill. But
okay, but on D?
Yeah, we'll have discussion from the clerks.
Yeah, this is for D only.
But this is only upon the rejection of a application that they are notified, correct?
Okay, and it's been represented to us that it was circulated to the clerk community and there no comment. Okay.
But I have a request to speak from Patrick Berry of the Clerks Association, actually, and Jessica Narduli too. And they probably wanted to be heard on the signature, but you want to be heard on this as well, Mr. Berry? On the notification of rejection?
Confirm that Marnie's correct. We don't have any objection.
Okay.
Okay, now I'll second Member Watson's motion.
All right, well, that's good. Then we can dispose of that one that's not controversial first. Any other questions on this? So, Ms. Malowitz, just to simplify this, this would, if an application for a vote by mail ballot is rejected under this section D, the election authority would notify the applicant that they were rejected?
That's correct, along with the reason for rejection, and they would also send along a vote by mail application for the voter to fill out.
Okay, so that's what we're voting on, and there is a motion by Member Watson, seconded by Member Cadigan. Any other questions or comments from the board? If not, let's vote on that one. Amy, could we have a roll call, please?
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Lineberry?
Yes.
Chairman Schultz?
Yes. All right, so that section will be adopted. Now, the other supplemental emergency rule, Ms. Malowitz.
So section 225.30C currently reads as follows: an election authority may not reject an application to vote by mail on the basis that the application does not contain the signature of the elector, unquote. It is my understanding that Mr. Berry and Ms. Narduli are here to argue that that rule should be revoked, although certainly correct me if I'm incorrect. And then we also have proposed language by Member Watson, and I can read that language at some point when we're ready for it.
Okay. Mr. Berry?
Yes, thank you, Mr. Chairman.
Yeah, would you like to be heard right now on behalf of the clerks?
That would be great.
Go right ahead.
It's just going to be we're just going to reiterate our position during the last call that we had. I did send a revised letter that went to the call containing our objection, and Ms. Mallory had asked to be more specific as to why we thought one section of the new legislation or the bill enacted legislation, our interpretation of it, and that is in the letter that we submitted. I assume that went out to the board. So I guess I would just leave it with, we will continue, we do want C stricken. We would hope that the board would withdraw the rules and then resubmit without C. That would be our ask.
All right. And I think all the members received, I think that was a copy of a letter on, I think it was actually to Jake, Mr. Barry, but we all got a copy of it. Correct. All right. Questions for Mr. Barry? I also, and Jessica Narduli spoke or signed up as well. Would you like to be heard?
Thank you, Mr. Chair. I don't have anything to add. We'd just be reiterating our arguments that's in the letter and that we presented to you at the last meeting.
What about Gretchen DeJane? She's the McDonough County Clerk, and I think she had filed a request to speak as well. Hadn't you, Gretchen?
I did, thank you. I'm the chair of the County Clerk's Legislative Committee. You know, we would just like to reiterate that because Illinois is a signature state, verifying those signatures is essential in us performing our duties as an elections authority.
Thank you.
Pardon me, Mr. Chairman. Can I ask a question here? Where
yes,
does this
sure.
go? If we adopt the clerk's position, then what? It goes to JCAR?
If we adopt the clerk's position, when we are filing subsection D, which we've all just approved, we will, instead of subsection C, say something like repealed or revoked, and the subsection C would be revoked and would no longer be effective.
What about the language that Member Watson submitted? Would that be in place?
If we chose to file that instead, if the board chooses to file Member Watson's language, I would file that language at the same time as subsection D, and that subsection C would replace the previous subsection C.
All right. Did the members of the board all receive that suggested language?
I did.
Yeah, it was emailed out this morning, and you might want to go over or just read it, Ms. Malowitz.
Certainly will do. Quote, an election authority may not reject an application to vote by mail on the basis that the application does not contain the signature of the applicant if, number one, a certification statement in substantial compliance with section 19-3 of the code is provided by the applicant, or number two, in the case of electronic filing, the appropriate box for certification is checked. If the application is submitted by email or non-electronic means and no signature is provided by the applicant, the election authority must, within 3 days of receipt of the application, return the original application to the applicant by U.S. mail and request the applicant's signature for comparison with registration as signature verification. The applicant may resend the original application with a signature by electronic means, U.S. mail, or personal delivery to the election authority, unquote.
Mr. Chairman, could I ask the clerks, what problem do they have with Member Watson's language?
This is Patrick Barry, Member Hain. One would be I haven't received the language, so that's the first time I've heard it. But it sounds to me there might be a contradiction on saying that we don't need a signature, if I heard that correctly, and then a process in which to verify or require a signature at the end. Did I misunderstand that? I'm sorry.
Should I recite the language?
Or Member Watson, do you want to respond?
My reading of what I submitted gives you your signature for verification and registration.
What?
At the beginning.
You want to read it again? You want to read it again, Marnie?
Certainly.
Thank you.
Quote, an election authority may not reject an application to vote by mail on the basis that the application does not contain the signature of the applicant if, number one, a certification statement in substantial compliance with section 19-3 of the code is provided by the applicant, or number two, in the case of electronic filing, the appropriate box for certification is checked. If application is submitted by email or non-electronic means and no signature is provided by the applicant, the election authority must, within 3 days of receipt of the application, return the original application to the applicant by U.S. mail and request the applicant's signature for comparison with registration and signature verification. The applicant may resend the original application with a signature by electronic means, U.S. mail, or personal delivery to the election authority.
This is Jessica Narduli with the Association of Clerks.
Yes, Jessica, go ahead.
Thank you, Chair. It's a lot to absorb just hearing it, but at the outset, I'm a little confused because it says, again, my notes, so I apologize if I'm incorrect in stating what was spoken, but it sounds like we can't reject an application for lack of signature if there's a certification statement complying with 19.3, but doesn't that require a signature? I guess I'm a little confused.
Mr. Chairman?
Yes, Member Cadigan.
Can I make a recommendation that this language, and I have some questions about Member Watson's proposal, that it be emailed to Mr. Berry and Ms. Narduli and anybody else on the call right now that has an interest in this, and we take a 10-minute break, and I think that we'll have a more productive discussion when that language is in front of all the stakeholders here.
Well, I don't have any objection to that. I think, we've probably gone far enough in the meeting that we need to have a break.
Member Watson, are you comfortable with that approach?
I don't have a problem with it. I just want to say for the record that it was my intention to make sure that the clerks received their signature. It was also my intention to indicate that the language in 19.3 requires a certification, and that I do not read into 19.3 that there's a requirement for signature.
Okay.
I read the language which says certification.
Okay.
So in order to satisfy all of the clerks in the state of Illinois,
right,
it was my intention to give everybody what they needed.
I think what you've offered is very constructive, and I think for us to have a real solid conversation about it, though, all the stakeholders and all the people that want to comment on it should have it in front of them. So
yeah.
I don't have any objection to that at all.
Well, let's take a break and reconvene at 12:15, and in the meantime, email this language out, please.
Okay, I assume that Marty, you have Mr. Berry and Ms. Narduli, and is there anybody else that wants to receive a copy of this from?
Gretchen DeJanes, who's on the call as well. Yeah.
I don't have. I can add Mr. Fogarty to the list.
Thank
Gretchen DeJames, did you say?
Well, yeah, she's with the clerks. Maybe if you get it to Mr. Berry and Ms. Marduli, they can forward it to Ms. DeJanes, who I assume is in Macomb.
Great, and I think Ms. McDonough might also be wanting that as well.
Sure.
So if the clerks don't mind circulating what I email to.
I thought Don Gray is on the call. Mr. Gray, do you want a copy of it?
I would. Thank you very much.
Good.
And Mr. Gray, what is your email?
Sure. Don, period,
Yes.
Gray, Gray, at CO, as in county, .sangamon.il.us. Thank you, Member Cadigan.
All right. Let's
Great.
take a break and reconvene at 12:15.
Thank you.
Excuse me. Question. This is Bill Redpath. I am a candidate who's been challenged. Is there any reason for me to remain on this call?
No, I don't believe so.
Okay. Then I was told that after this call, that there would be a meeting regarding my situation. Is somebody going to contact me? I certainly don't want to miss that.
Right. I think you're going to get an email from your.
Get on to. Pardon?
I think you'll get an email from your hearing officer. Isn't that right, Ms. Mellons?
That's correct.
Okay. I'll be looking.
Thank you, Mr. Redpath.
Okay,
All right.
you.
All right. We'll be back in 10 minutes.
Is anybody else still on here? No? There's a few of us. Yeah, I'm a candidate that hasn't heard anything about my situation yet. So am I still somebody that needs to remain on here? Or?
Has someone objected to you, Mr. Grimm?
Yeah, Riley, and I haven't.
Oh, yeah. I see you number 3M on the docket. Were you not able to appear at that time? I think it was called earlier.
May I ask who is speaking right now?
This is Chad Grimm and Riley V. Grimm. We had asked if I was here. I had agreed with Bill Redpath and said that I got on it about 5 minutes after because I didn't receive any of the notifications.
Sure.
Mr. Grimm, you'll be appearing in front of me and I'll be placing a phone call with you. My name is David Herman. I'm a hearing officer that's been assigned to your case. I'll give you my cell phone right now and you can call it if you need any further clarification, but I'll be trying to get either a teleconference or an email exchange to set up an initial case management either today or this afternoon. If you have something to take down my phone number, I'll give it to you right now, Mr. Grimm.
Yes.
It's 217-502-3024. Again, 217-502-3024. And my name is David Herman, Herman.
And so we'll be chatting later today.
Well, I'm going to try to coordinate with Mr. Morphew, who was the attorney for the objector, to see what his schedule is, and I will either do it today or tomorrow. There are also important deadlines that you need to get a copy of the rules of procedures. There are deadlines that are upcoming this week that you need to make sure you're familiarized yourself with so that you know if anything needs to be filed, what's going to happen. Pay particular attention to the exhibits. Exhibit A has some deadlines, and Rule 8, which contains information relevant to subpoenas if you have any subpoena issues, okay? But that will all be discussed in the pretrial conference, sir, our initial case management conference.
Okay, so I'll just wait to hear from you.
Yes, sir.
All right, thank you.
Sorry, Marnie.
Good afternoon. I have a question then. Mine's sort of similar. I'm trying to figure out, do I stay here for my candidate's objection from Mr. Jones and Ms. Adams?
What's your case number, sir?
Hold on a minute. Sorry about that.
502 or 503?
I think I'm the 3. Let me.
It's both of them.
That's Mr. Krasny, and he will be contacting you. We have not been provided the information to contact candidates yet, but as soon as we get that, because obviously the state board was still in session and the general counsel and the attorneys are still busy, as soon as we get that information, either Mr. Krasny has both of those cases and he will be reaching out to you, sir, to coordinate a hearing, what's called an initial case management conference. Just like I told the individual that I have in my matter, get a copy of the rules, you need to read those, be familiar with them, and pay particular attention to the deadlines. Things happen fast.
Oh, okay. So then.
Do you have Mr. Krasny's information by any chance, like an email address for him?
Yeah. Is there something to get a contact? Because we weren't told.
Mr. Krasny will reach out to you, sir.
Okay, because
that's why entries of appearance are so important, that you have both your cell phone and your email.
We gave my candidate myself gave all the information.
That's correct, and you will be contacted. That's correct, and you will be contacted, sir.
All right. So, can we leave this meeting for the day, or?
Marnie, nothing else is happening with these cases, are they? No. Yeah, you're free to leave this meeting. Your case will not be discussed any further, sir.
Appreciate it. You have yourself a great rest of the day.
You too, sir. Have a good day.
I have one final question. This is Valerie Adams.
What's your case number, ma'am?
502 and 503, just the one you were speaking.
Yes, ma'am.
I was wondering if Mr. Gonzalez is an attorney appearing on his.
I'm not a lawyer in practice. I'm just the.
Hold on, you guys. You guys can get all that in front of Mr. Krasny. That's not to be discussed today in this open forum. You guys just need to get together with Mr. Krasny. Any problems you have, you can work out with Mr. Krasny. He's a very good hearing officer, seasoned. He'll take care of all the issues and address the concerns by either party, okay? The merits of those issues should not be discussed right now, and probably argument is, if you read the rules, will not be taken today, but you'll have an opportunity to set forth your position in writing and orally later on in the process, okay?
Okay, thank you so
Okay.
much.
Yes, thank you both.
I have a question. Kathleen McManaman, case number 105.
That's not
Am I
me either.
to- Am I
That's
to
Mr.
remain?
Holmes. No, there's no need. Roger Holmes is also an experienced, he's a retired judge. He's a very experienced hearing officer. He'll be contacting you if you provided the information to the state board.
This is Roger Holmes. As soon as I get the email from general counsel, I will be setting up, I'll be contacting you by email, and if necessary, we'll set up a Zoom meeting this afternoon.
I apologize, Roger. I didn't see you I'm on my iPad. I didn't see you on the call. I apologize.
That's okay. I'll turn my light back on. Does that answer your question, Ms. McManaman?
No, it did not.
Okay, what's your question?
My question was, do I need to stay on here? You were, I thought you were addressing Mr. Holmes, so.
General counsel says there's nothing further for candidates. As soon as their meeting is over, I expect that I'll get the email from general counsel's office with all of your contact information for all of my cases, and I'll reach out to you this afternoon.
Okay, thank you, Mr. Holmes.
You're welcome.
Real quick before you go, Ms. McManaman, I just wanted hearing Officer Holmes while I have you and we're all live here. I just figured I'd let you know I have another appointment at 3 o'clock today, a prior engagement. So just to kind of give you a heads up on that as far as the timing of whatever meeting we have later today.
All right. What time does that meeting end?
It should be done by 4.
Okay. I teach from 5:30 to 9, so we'll try to get this in. As soon as I get the contact information, I'll reach out to you. We'll try to get it done before your 3 o'clock.
Thank you very much.
All right.
I also have, I think, a 3 o'clock appointment, so.
Okay. And Ms. McManaman, what time does your 3 o'clock end?
Depends on what the mass is.
Okay. All right. Well, we'll hopefully be able to do this before 3 o'clock. If not, I'll reach out to you after between 4 and 5 and see if we can reach you. But hopefully we'll get it done before that time.
Okay, thank you.
You're welcome.
If you don't mind me piping in for a moment. So no action is taken by this body today outside of the hearings because from my understanding in your agenda, any objections filed on certain bases would be overruled in light of the court's order in Libertarian Party of Illinois v. Pritzker. Are they being determined by those hearings, judges, or how exactly is that being worked out?
Sorry, this is Marnie Malowitz, General Counsel. The hearing is not currently in session, so if any questions can hold off until the chairman has returned, that would be wonderful. Thank you.
I will do so. Thank you very much.
Hello? Is everybody back?
I think we're waiting on the chairman still. I believe he just got back in. Chuck, are you able to hear us?
Apparently not.
Yeah.
Yes, I can hear.
Is this Member Haynes?
Yes, ma'am, it is.
Okay, so you and I are the only two back, and Marnie? Maybe Marnie's not back either. Well, I'm reading 12:18.
I'm back. Member Cadigan's here.
Member Donahue's here.
Member O'Brien is back.
Well, Member Watson and Member Haynes are here.
Chairman Schultz is, he's showing up as he's participating, but I'm not able to hear him yet.
But while we do that, maybe we could just confirm that Mr. Berry and Ms. Narduli, and Mr. Fogarty and Mr. Gray, did you receive copies of the Member Watson's proposal?
Yes, Member Cadigan, this is Patrick Berry. I did receive a copy and have gone over it, and I really do appreciate Member Watson's thought process on this. I appreciate her trying to...
Let's wait until we have discussion on it until Chairman Schultz joins us.
And I too, Member Cadigan, had received the language. Thank you.
Mr. Fogarty, are you still with us?
I am. I don't see it in any of my inboxes, but I'm looking just to make sure I'm not missing anything.
Mr. Fogarty, it was sent to your Gmail.
Okay. I will check there. Thank you.
Member Cadigan, I received it from Mr. Berry. Thank you.
Okay, thank you, Ms. Narduli.
Thank you, Council.
You have it, Mr. Fogarty?
Yes, I do. Thank you.
Okay, great. Amy Kelly, I'm not seeing Chuck on here.
He was in and now he's gone. I'm trying to see. Oh, it's CWS's iPhone is his screen name.
If there's more bad news from the St. Louis Cardinals, we may have lost him for the day.
Does anyone have his cell phone? I don't have that number to check with him.
I do.
Okay, thank you.
Marnie? Marnie? Marnie, did you get a number for Chuck?
I can, let me try Chuck right now.
I think Mr. Cadigan is checking with him, guys.
Okay.
Thank
And
you.
perhaps he's having technical difficulty.
Hi, Amy. I've got Chuck on my cell phone. So Chuck is going to preside over the meeting via my cell phone and Zoom feed. So
How about that? Can everybody hear me?
Yes.
Okay, good. Sorry about that. I'll just be on speakerphone here for the rest of the meeting. To reconvene then and deal with this proposed rule. And I did speak with Member McGuffey. She's been participating in the meeting but unable to speak up. His preference is now that we have rule for section D on the notification if the application is rejected, that we just then eliminate the other rule. So that's his feeling, is that just to eliminate the language that says that it has to.
So he wants to just strike C and leave D?
Yeah, exactly.
You know, I really don't have a problem with that.
Well, I think that would get it done. What do you think, Mr. Gagnon?
I think so. I'd like to hear from some of the other stakeholders here that we've got in the meeting.
Yeah, the clerks, Mr. Berry, have you had a chance to read that proposed language?
Yes, Mr. Chairman, I have. And again, I want to thank Member Watson for her thought process on doing this.
You worked hard on that all weekend. But what do you think now that we have the notification upon rejection of an application language? Do we just eliminate that language that says it can't be rejected for lack of signature?
You mean strike C under the current emergency rule? So you would withdraw the rule, resubmit without C, and add D. D would become C. Marnie, is that correct?
I think for clarity, I would propose keeping D as D and showing C as repealed, just so as not to confuse anyone who was previously following C. But ultimately, JCAR and Secretary of State may have their own opinions on that. So I'll certainly take their suggestion, however they suggest.
Okay. Without the labeling aspect, I think Mr. Berry's saying that would that get the job done?
That would satisfy the clerks, yes, Mr. Chairman.
Clerk Gray, you've been following this along. You understand what we'd be doing here? You think that's a sensible approach?
I believe it'd be a great sensible approach. You know, all jurisdictions, all county clerks, you know, want those who have an intention to vote by mail to vote by mail. We would reach out to anyone who was not compliant, substantially compliance to the application or missing elements. So we want to have that happen. It gives us clear procedures to be able to do so. We would have anyway, and I think it's a great way to proceed forward.
Okay, Mr. Fogarty?
I echo Clerk Gray's comments, and I appreciate all the thought that has gone into this. This makes a lot of sense from where I'm seated. Thank you.
Okay, great. Mr. Chairman, then I will, Member Watson has worked hard and given a lot of great thought on this. I'll let her make the motion then.
So I move that we repeal subsection C of the Notice of Emergency Amendments and leave subsection D as the process for rejection.
All right, I think that makes sense. I mean, I think everybody as long as we know that a applicant is going to be notified of the rejection and chance to cure, that seems like the way to proceed.
So I'll second Member Watson's motion, and I will encourage, I'm sorry, Chuck, Laura Donahue's raising her hand here.
Okay, Member Donahue, go ahead.
Sorry, wouldn't it be probably cleaner if you withdraw the rules and resubmit without Section C? I mean,
well, I think Member Watson's saying Section C would be revoked, right?
Yeah, I think to Marnie's point that there are clerks out there that are currently have this in their possession and are we're preparing to proceed according to the emergency rule as it was previously submitted. Now that rule would if they wondered why C was changed, it would just say repealed, and D would remain designated as D. I think from a drafting convention, that would probably be the preferred approach. Like Marnie said, JCAR and the General Assembly may have different thoughts on that regard, but I think Marnie's approach is from a drafting convention the appropriate one.
okay.
All right.
Now I'll second Member Watson's motion.
Member Donahue has seconded the motion.
Okay. Yeah, we've heard from the clerks. Is there anybody else on the call that wishes to be heard on this? If not, let's have a vote. Amy, could you call the roll, please?
Mr. Cadigan?
Yes.
Ms. Donahue?
Yeah. Yes.
Mr. Hain?
Absolutely, yes. Great compromise.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
Yes.
Chairman Schultz?
Yes. Thank you. I think that worked well. I appreciate the clerk's input, and I especially appreciate Member Watson, who spoke with numerous times over the weekend, and she and also our general counsel worked hard on this over the weekend, so I commend them. But that sounds like a good result. We have other business, Mr. Santos?
I don't believe we do, other than I think Marnie wants to provide a brief litigation update in executive session. Is that right, Marnie?
All right. Well, before we go to executive session, let's have our comments from the general public, because they've been waiting, and I did have a request to speak from Antonia Harlan, who had called me, and I suggested she speak to the full board about the drop boxes. Ms. Harlan, are you on the call?
Yes, I am. Can you hear me?
Yeah, this would be your chance to speak to the board.
Okay, great. Chairman Schultz and members of the board. My name is Antonia Harlan, and I'm a 33-year resident of the city of Naperville in DuPage County, Illinois. I'm addressing the board today about a most serious set of threats targeting our upcoming November 3rd general election, in which the actions of your board can serve a critical role in its administration. There are two major threats that will affect Illinois voters' ability to cast their votes, with the end result of these threats culminating with the suppression of the voice of the people, which is a direct assault on our democracy. Voters will find themselves having to make the decision not to show up at the polls, either out of fear of contracting COVID-19 or being discouraged that their mail-in vote will only be hijacked due to the delays with the U.S. Postal Service. So what does it matter? Voters need reassurances that their votes matter, that they can vote safely, and that their vote will be counted. COVID-19 has affected nearly 180,000 people in Illinois. It is no secret that this pandemic would deter thousands of voters from casting their votes at their local polling place. This virus is a real threat to voters nationwide, and certainly Illinois is no exception. I am sure you would agree that no one should be required to put their lives and that of their families in jeopardy in order to exercise their right to vote. As an African American, my ancestors have given their lives for this right, and no one, regardless of their race or party of choice should expect that such a sacrifice is still yet required. The second threat is the slowing down of the U.S. Postal Service in delivering the mail in a timely manner, which would include millions of ballots that have been mailed out to registered voters. Some of the issues that are encumbering the process include a newly appointed postmaster who has implemented policies that had slowed the process, a cash crisis at the U.S. Postal Service, which affects the paying of overtime, as well as the effects of the COVID-19 virus on its more than 600,000 employees. It is a fact that the slowdown has already begun at this 245-year-old government agency. Based on what we know today and what the expectations are for November 3rd, Illinois must be prepared to collect and count the estimated 5 million vote-by-mail ballots as efficiently as possible. Chairman Schultz, Vice Chair Lineberry, members Cadigan, Donahue, Hain, McGuffich, O'Brien, and Watson, please take a proactive stance in resolving these issues by adding additional secure drop boxes within the election authorities throughout the state, thus ensuring that all votes are counted and our voters are represented. Additional election funding can be requested from the federal government in order to provide the secure drop boxes needed. My county, DuPage County, has drop boxes available at their polling places and as well as at their county campus. But many more will be needed based on the anticipated sheer volume. This will be true statewide. Secure drop boxes will add the assurance that those who do not want to stand in line at their polling place or risk the chance that their mail-in ballot will not make it to their local election clerks or commissions in time to be counted will have their vote counted without fear of having their voice denied. These drop boxes are more important than ever before. It's imperative that at this time, the Board of Elections does not think outside the box, as we say when we're looking for exceptional ideas, but this time the exceptional idea falls inside the box, the drop box, where voting ballots can be deposited safely, securely, and guarded whenever necessary, without risk to the voter's health and any delay by the U.S. Postal Service. I'm asking for two things. First, please use your administrative powers to request the necessary election funding from the federal government in order to distribute these funds to aid those election authorities in need. And secondly, disseminate information on these drop boxes to the public on their availability and security they will provide for mail-in ballots. I'm sure that many residents aren't aware that drop boxes are available. Educating the voter via advertising by way of newspaper, ads, PSAs, mailings, press conference, whatever is necessary for outreach to reach the voters. You can make that difference in the Illinois vote. I thank you all for your time, and I hope we can agree on the necessary expediency in order to move forward on this issue. Thank you again.
The CARES Act funding, which is a pass-through the Board of Elections to the local election authority, does allow for funding for drop boxes, but I believe that is within the discretion of the local election authority as to how to spend those funds. Is that correct, Mr. Sandboss?
Yes, Mr. Chairman, that's correct.
Might not be drop boxes for every jurisdiction. I think it's going to be up to the local election authorities, but we could stress that importance, certainly. Maybe we could discuss this on the 21st, Mr. Sandboss. For the rest of the board, I'd ask the executive director to give us a report August 21 on all the CARES funding and where it's gone and what's going to, along with our HAVA balance as well, how much is left and so forth, so that we can see what else, where we stand on funding these extraordinary expenses like drop boxes and postage and printing. Any board members wish to comment or have a question for Ms. Harlan?
No, I agree that the U.S. Postal Service is potentially a weak link in the chain here. And I don't think it's the result of any recent action, particularly in the city of Chicago. Mail service has been historically unreliable. And I don't know what we do as an agency between now and then to address that, except for the promotion of the drop boxes in the manner suggested by Ms. Harlan. So it's something that the local election authorities should be encouraged to do. It's my understanding that the U.S. Postal Service recently reached out to our staff, and Brent Davis of our staff had a meeting with senior postal officials from the Chicago region, and they gave assurances that their best efforts would be made to accommodate all the ballots that are going to be delivered. But again, I think mail service in Chicago, and literally I recall being a congressional staffer in the late 80s, and this issue was raised then, and it's been a persistent thing. If you talk to any federal office holder, one of their constituents' most prominent complaints is mail service. And we've got a vote by mail program in the state that need to be stood up very quickly. But a critical component to that is performance by the U.S. postal system. And I have concerns about whether or not just in Illinois, or not just in the Chicago area, but around the state, if the Postal Service understands what's coming their way and if they'll be able to deliver all the ballots on time. So as part of our education efforts, people are going to mail them in. We ought to encourage getting them early and mailing them early.
Can I interject a little bit?
I know Matt Dietrich's all over that, and Vice Chairman Linneberry and I are going to do a couple events, I think, that have been lined up. But yeah, we really definitely need to raise the level of public awareness. But thank you, Ms. Harlan. And Mr. Davis is on this call, our director of elections. So he'll be dealing with these local election authorities and can make them aware of the need of drop boxes.
And can I just say that I understand that Chicago does have an issue, but areas that never had issues before with the U.S. Postal Service are already experiencing that because they're not allowed to work any overtime because of funding. And so they have to leave mail behind. And we just can't take that risk with our ballots. And so I would hope that you would encourage those local authorities to have drop boxes. Thank you so much.
You're welcome. Is there any other member of the public that wishes to address the board today? If not, is there a motion that we adjourn into executive session?
So moved.
Second.
For the purpose of litigation, Mr. Savos, for update?
Yes.
Okay, we'll limit it to that. And motion made, seconded to adjourn into executive session. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Scholes?
Yes. All right.
Mr. Chairman, are you going to make sure that all the other calls are off before we?
Clear the room.
Yeah.
You can just tell us whenever you're ready, please.
Yeah, Amy, why don't you just go ahead and do whatever you need to do to make sure that the call is confined to those who are required to participate in the executive session.
This is Brent Davis. Amy was kicked off of the call and it has kicked over the host status to me, so I will be taking care of that.
Okay, all right, Brent, everybody but the board and executive director and general counsel. Thank you.
Mm-hmm.
Recorder.
And if my attorneys can be on as well. Thank you.
Okay. Fine. Open session, all those in favor?
Aye.
Aye, opposed, so ordered. We'll now sit as the State Board of Elections in open session and take up actions in executive session. Member Cadigan.
I make a motion that we adopt the position of the Illinois Municipal League in seeking clarity on whether election day applies to municipal and other units of local government in the state of Illinois.
All right, is there a second?
Second?
Second.
All right, roll call, please, Amy.
Mr. Cadigan?
Yes.
Ms. Donahue?
Aye.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
Yes.
Chairman Schultz?
Yes. Is there any other meeting, business to come before the Board of Elections today?
No, I'll make a motion, we adjourn.
Second.
All those in favor? Aye.
Aye.
Opposed? So
Aye.
We'll meet on the 21st. Maybe we could have an in-person meeting. We'll just have to see how it goes with the office. But we also may have a special meeting in the meantime if, and Mr. Alex will let us know about that. Thank you all for your attendance. Sorry about all the technical challenges.
Thank you.
Thanks, guys. Have a good week.
Thank you.
Have a good week. Bye-bye.
Bye-bye.
Bye.